Greetings. My name is James Bell, Jim Bell, as people tend to refer to me. This segment will be talking about the defense portion of the criminal trial. Now, as we've explained in prior segments, we went through jury selection, the opening statements of the prosecution. We've also discussed the government or state's case against the defendant and a motion for judgment of acquittal. Now we're going to talk about the defense proof. What we have here at this stage, the defendant's opportunity to tell his side of the story. Most people do not do that, and there are innocent reasons why a person would not testify in their own criminal trial. One, some of the nicest people I know just make horrible witnesses. There are people that sit on the third pew of the church every Sunday that just get rattled if they had to stand up and say something publicly. And juries judge people by their demeanor on that witness stand. So that may be a consideration. Another consideration is the person may have had an old conviction for something that has nothing to do for what they're on trial for, but they don't want that to come out. A third reason is they may be just guilty and don't want to lessen the government's proof. There are other reasons. The person may not have good recollection. The person may not add anything to the story. Or another good reason is a lot of times the defendant or the person on trial would have given the police another story, and it shortens the trial just to say, well, you heard what he had to say about it. There's no reason to bore you with any other details. So there are several reasons why the defendant wouldn't testify, but if that person does get on the witness stand, he's subject to cross-examination, and the prosecution's just lying in wait to ask questions that can go back as far as the court will let them. And some judges have a wide range of openness on cross-examination, while others have a little bit more narrow legal strike zone, as we like to call it. The defendant can call witnesses, or he cannot call any witnesses. Many a times I've told the judge, I said, charge the jury, they've heard all the information. Remember, in a criminal case, the burden stays on the prosecution and it never shifts to the defense because it's impossible to prove a negative. So the government's got to prove it, the state's got to prove it beyond a reasonable doubt as to all the elements and as to the conduct of the person on trial. So, that person testifies or doesn't testify. He's got witnesses that testify or doesn't testify. There are a special set of witnesses. The prosecution may use that special set of witnesses, or the defense may use a special set of witnesses, and that's called an expert. Both sides have, and most lawyers don't know this because most lawyers don't try cases, but there is a rule that we have used very effectively, and it's called an interim commentary on expert witnesses. So a physician gets on the witness stand, and I call that expert as my witness. I'm allowed to stand up with the permission of the court and say, good afternoon, ladies and gentlemen. Dr. Forster is going to testify in this case. He is a physician that he examined the deceased shortly after the shooting, and he has concluded to a different result than what the state's expert witness has to say. And that gives us interim commentary, and then we put the doctor on, qualify the doctor, and let the doctor tell all that he did, but it allows us to speak in good language and communicate that information to the jury and eliminate some of the expert language that may be ambiguous or confusing to a jury. After the defense rests, the state has a right to present what is called rebuttable proof They can prove the case by opening up their proof and calling a witness only to rebut something the defense has put forward. And that will conclude all the testimony. Finally, the judge will charge the jury. Now, does that mean, all right, give us $25? No, it doesn't mean that. He gives you a legal charge that says this is what the law is. Go back, do justice, apply the facts as you determine them to the law of the case, and render a true and just verdict. Folks, y'all have heard the various parts of the trial. Once a verdict comes back, we'll talk about that process later. But if you got any questions about any portion of this commentary or other segments, feel free to give us a call at 865-637-2900, or you can come to our webpage at www.jamesahbell.com. Thank you very much and have a great day.